Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of BBA LLB, and I study at Bharati Vidyapeeth New Law College, Pune. And today's topic would be right to die. So, the right to die is a concept which is based on the opinion that a human being is entitled to make any decision about ending his or her life. This also includes undergoing voluntary euthanasia. Possession of this right is often understood to mean that a person with a terminal illness or without the will to continue living should be allowed to end their own life or to decline life prolonging treatment. The primary question here that arises is whether people should have the right to die and what may be the principle justifying such right. Right to life is a basic natural right of human beings. In India, it is a fundamental right guaranteed under Article 21, that is Part 3 of the Constitution of India. Article 21 confers an obligation on the state to ensure good quality of life, livelihood, liberty, and a dignified life to the people, both citizens and otherwise. This right to life has been interpreted by the Indian judiciary in various ways so as to include within its purview several new rights such as the right to live with human dignity, right to livelihood, right to shelter, right to privacy, right to food, right to education, right to get pollution-free water and air, and some other rights which are quite essential to improve the condition of the life of the people. That is for the true enjoyment of the right to life. The question that right to life can include within its ambit the right not to live or right to die is one that has been debated in several cases. Death can be defined as the termination of life. Death can be categorized basically into two kinds. First is natural and second is unnatural death. It can be caused by the action as well as the inaction of a person. Causing the extinction of a life unnaturally by the action of oneself over himself or over someone else is morally bad as well as legally punishable. Every living human being in this world wants to live a long life and by every possible means wants to increase the longevity of their lives, and promoting end of such life is not intended result of this right. For a common man, when life becomes more painful and unbearable than death, then it is very normal for him to desire death. This voluntary embracing of death is known as euthanasia or mercy killing. Euthanasia is also termed as Dayamaran. Some people, as the great saints of heroic person, embrace Ichhamaran or willful death when they feel that they have achieved the purpose of their life. There are different types of voluntary death in our country, like the Sati, Johar, Samadhi, Prayopation, etc. The history of the legality of right to die in India starts from the case of State versus Kumar, where the Delhi High Court criticized Section 309 of IPC as an anachronism and a paradox, and then it is followed by varied views of different high courts on Section 309 of IPC. In the case of Naresh Malhotra Sakre versus Union of India, the court observed the difference between euthanasia and suicide. It was discussed that suicide was an act of self-destruction to terminate one's life without the aid or assistance of any human agencies, whereas euthanasia being different as it involves the intervention of a human agency to end one's life. This mercy killing is from nowhere covered in Section 309 of Indian Penal Code, which states that attempt to commit suicide, whoever attempts to commit suicide and does any act towards the commission of such offence shall be punished with simple imprisonment for a term which may extend 1 year or with fine or with both. In P. Rathinam versus Union of India, the court giving relief to the measures attempting suicide, Section 309 was held to be irrational and deserves to be effected from the statute book and humanize our penal code. It attempts in doubly punishing the man who is tremendous pain and would be undergoing ignominy because of failure to commit suicide. Soon this was overruled in the case of Jian Kaur versus State of Punjab, and it was held that the right to life does not include right to die or to be killed. It was further held that right to life was a natural right embodied in Article 21 but suicide was natural termination of extinction of life and therefore incompatible and inconsistent with the concept of the right of life. That's all for the topic today. Please comment and like on the video. Thank you.